Okay, I'm going to go ahead and get started. Tori, if you can hear me, I think we're recording and we've got a number of people on here. People will start joining, but we're just going to be doing some preliminary stuff first. We're not going to get into the real meat and bones of this. If you have questions, in the duration of this, feel free to write them in. I might not get to those until the very end. But we'll try to make sure I have time to address questions. Hi, everybody. James Owen. We, with Renew Missouri, are going to be talking about the new HOA solar law that was signed into existence by Governor Parson and going into effect in just a couple of weeks. And we are going to be talking about that today and how real estate practitioners can comply with it. Our agenda, yes, introduction to our group, as well as to the presentation, a recap of the history of solar and property rights issues in Missouri, new legislation and what that legislation does, what it says, compliance with the new legislation, as well as concluding thoughts that also involve some of the case law out there about this. Oh my gosh, we're going through these slides really fast. My producer Tori Cheatham, who helped make these look really good, she's keeping me on task. Who is Renew Missouri? We are a 501c3 advocacy group that was founded 16 years ago. Our focus is advocating and championing renewable energy and energy efficiency. We primarily do that in front of the Public Service Commission in Jefferson City. We also work in front of the legislature. We also work with municipal utilities around the state like Columbia, Springfield, Independence, as well as member owners of rural electric cooperatives. We do that. Go back. Okay. This is very jumpy. But we also work with businesses. We work with a lot of people in the solar energy industry. MOSIA is a very strong partner of ours. And I know there's a number of MOSIA members on this particular webinar, so welcome. But we also work with corporate entities who are interested in access to renewable power, energy efficiency. We are largely working on trying to make Missouri a more regulatory friendly state for all of that energy production, demand related issues with energy efficiency. So that's who we are. And next slide, please. Who am I? Well, I'm James Owen. That's me. That's an old headshot of me. I probably need to update that. I am the executive director of Renew Missouri. I am essentially the officer and the face of the organization. I do a lot of our government affairs work. I do a lot of our expert witness testimony, not just in front of Missouri regulators, but also regulators in Kansas as well as Kentucky. Those are some other states that we've worked in. I am a lawyer by trade and by education. I received my JD from the University of Kansas School of Law in 2003. Before that, I graduated from Drury University down in Springfield, Missouri. I am from the Springfield area. I practiced law down there for a number of years. I was appointed as an associate circuit judge there as well. So yeah, I'm a big deal. Next slide, please. Okay, previous issue. Okay, so one thing I should note is with this work that Renew Missouri does. Okay, so first of all, we're a very kind of lawyer intensive organization right now. We have 5 full-time staff members. 3 of us are attorneys. Most of us are doing some sort of legal work. I think anything involving energy policy, it's important to have people with that kind of, not only with that background and that knowledge, excuse me, but also with a law license where we can actually go out and do this work. And that's important with this kind of HOA issue, HOA standing for homeowner association. And just kind of as a very basic fundamental point about homeowner associations, those are planned out neighborhoods that have restrictions and covenants that when you buy a house in that HOA, you sign on to those covenants with the agreement that you're going to follow them. And that is going to create a neighborhood that has uniformity, that has consistency, that's the idea of a homeowners association. Maybe you live in one, maybe you don't. I don't live in one. I live very close to a neighborhood association in Columbia, but that in Columbia, Missouri, but that is kind of a different beast. An HOA is a nonprofit. It is managed by the group of the citizens who are also your neighbors, and they do have special laws under the Missouri statutes that kind of govern how they're supposed to operate. One of the things that they don't like or have historically not liked when you're talking about uniformity or consistency is they don't like things being put on your roof. They didn't like satellite dishes in the 1980s. Now, the federal government eventually said to HOAs that this is something that the FCC regulates. And so therefore, you don't get to regulate whether people get to have satellite dishes on their roof or not. I think we're pretty close to having a decision by FERC in regards to distributed energy resources that is going to make that kind of a similar issue with solar panels, but that's not the case right now. Right now, you have a lot of homeowner association covenants around the state. They've drafted this language. Some of it's old, some of it's been passed on from other lawyers. And it seems written with the idea and image in mind of what solar panels used to look like in the 70s and 80s. Very monolithic, very big, very bulky, not very nice to look at. I'm a movie guy. I like movies. I think about the monolith at the beginning and end of Stanley Kubrick's 2001. And then once this language gets in there where they either ban solar or they put significant restrictions on solar, though that's there and you've signed it. And generally you don't get to be in a situation where you get to negotiate away certain elements of your HOA covenant, because that's the precise reason we have HOA covenants, is because we, they want to make sure that everyone's house looks similar. It doesn't run entirely afoul of section 442012 of the revised Missouri statutes, which explicitly declares solar as a property right. Because here's the thing, a property right can be contracted away. Even if the Missouri legislature said that's something that you're entitled to, it isn't to say that you couldn't buy a house in an HOA, sign a covenant or restriction that says, I'm not going to put solar on my roof, and then that be what you have to live with. That's very possible. It could also be possible that in addition to just having not having very much negotiating power with your HOA, it might be that you're not even thinking about it. When you think about all the closing paperwork that you have to sign at a closing when you buy a house, you have to sign your life away. You're signing a million things. The closing company would almost certainly put that covenant and restriction in front of you. 9 times out of 10, you're not going to read it, which is not an excuse to say that it's that you shouldn't be responsible for something you don't read. You did sign it. But you're usually just not thinking about it. And that's kind of a previous issue there. Next slide, please. Yeah. Okay. So I want to get in a little bit about that property right. And we kind of already talked about this a little bit. This is another reason why I don't like PowerPoint very much, is I start talking about something on one slide, forgetting that I wrote the exact same thing on the next slide. So I've kind of got this, I've kind of got some of this already covered. But the language that's relevant under this is the right to utilize solar energy as a property right, but eminent domain may not be used to obtain such property right. So there's that one limitation to how you declare. You can't use, if you have a right to solar, you can't use that to encroach on someone else's property. That's the limitation. Again, that can be contracted away. But however, I think it's important to point out this statute when we're talking about this new law, because we had this question when we were testifying in front of the Senate Energy Committee about this legislation, where somebody said, why aren't you proposing a bill that says you can have an extra high fence, or that you can have a dog kennel in your backyard? And the simple fact is the reason why we're not advocating for those things as opposed to solar is because having a dog kennel in your backyard or having an extra long fence is not, it's a property right defined under statute, under an existing statute. So to me, that makes solar something that that transcends other things that you might waive your rights to in an HOA covenant. That was what we, that was, I think, kind of the reasoning behind that. Next slide, please. Okay, so again, I mentioned something about how, Renew Missouri has a bunch of lawyers. What would normally happen is we would get a call. Renew Missouri would get a call, maybe from a solar installer or maybe from a homeowner. I bet we got a dozen of these every year. And it was not necessarily in one part of the state, although I was telling someone the other day that it seems like this is a bigger problem in Kansas City than almost anywhere else. Someone would want to put solar on their roof. They'd contact a distributive generation, solar installer, get some quotes, get some interest. Somebody in the neighborhood would notice that there was a solar truck sitting in front of someone's house. They would go tell the board of directors, and then all of a sudden they would get a letter from the HOA board or from a lawyer saying, you can't do this for whatever reason. Usually, I mean, I talked about there being a ban and that coming from older language or really strict language. Usually, most HOA covenants are completely silent to this. What they almost all say is, well, if you're going to do any kind of modification to your property, to your house, you've got to take those modifications, those proposed modifications, to what is called an architecture control committee, an ACC. And that's like a subgroup of the board of directors that will review specs, will review plans, and make a decision on whether or not you should be allowed to do this. Often there is next to no guidance on how these ACCs, these people that are on these committees, are supposed to evaluate any kind of modifications, let alone solar, let alone like this, this photovoltaic, device that you're putting on your roof. It's very technical, very scientific. Yeah, so very rarely do they even speak to this. They just say, go to the ACC. Next slide, please. Yes, the ACC. So yeah, again, they don't have any guidance. These people look at these, and oftentimes the people on this committee, either have a very strong opinion. They don't like solar. They think solar is an eyesore. They think it's going to drive down property values. An example I'll give you is of a client. I guess he was a client of ours. I won't say his name. We did file a lawsuit on his behalf in Taney County. He came to them, this ACC, and said, hey, I want to put solar on my roof. And they said, well, why don't you go get permission? Why don't you get signatures from your neighbors, your immediate neighbors? And if they all sign it, that's fine. Which, by the way, that wasn't in that wasn't a covenant. That wasn't in the restrictions. That was not in any bylaws. That was just something they came up with because they thought that would cause us to go away. Sure enough, this guy had like 8 or 9 neighbors that were kind of like, I guess, in the eye line of this roof. And all of them signed it except for one neighbor who said, well, I moved from Arizona. I know someone who got screwed. That's their word, not mine, on some solar panels, and I just don't like them. So this guy didn't even have an objection to like the look. He just had an objection to the fact that he knew a person that had issues with installing solar. So they didn't get all the signatures, and so then the ACC just denied him. Again, this was not well spelled out, and we tried to use the argument under 442 under the solar property rights statute at 42110, to argue that. We ended up settling it. The settlement was, and this is public record too, that they just gave him a variance for for his solar array. Didn't change the rules or anything. So if you go to your ACC, or there's just an outright ban, or there's something that's just otherwise is kind of, vague or confusing about your covenant, or is unspoken on your covenant, generally, and they deny you anyway. I mean, generally, if you were to go try and put up solar on your rooftop, they can try to fine you. They can try to put a lien on your property. They can ultimately make you take it down. There are pretty strict rules about following those covenants, and sometimes that involves, that can be really expensive, or you would potentially get asked to move. That's if they were to try to enforce that, they could. So your only option was to enforce it in court. That's where these landowners, these homeowners would reach out to us and say, hey, what can we do? You write a letter to the board explaining what the law is. They either say, okay, well, we're going to change our mind, or they say no. They more often than not said no. If they say no, one of the things I would always tell people is be prepared to sue them. Because you don't send a demand letter unless you're really serious about that, and you're not if you're not going to act upon that, if you get your demand rejected, it doesn't make a lot of sense to send it. Very few people end up wanting to pull the trigger on that, just because they are literally suing their neighbors. They become a little bit of a pariah in the neighborhood. One of the things they like about living in an HOA is it's tight knit. They know everybody. When they become the person that sues the HOA, then that becomes a larger, more social problem for that homeowner. Next slide, please. So to avoid this, next slide. Renew Missouri for the past couple of years has worked with other solar advocates, the Solar Energy Industry Association. And for a number of years, we've been kind of looking at this, at a law that would prohibit HOAs from banning solar outright. Instead, being able to put reasonable rules and restrictions in place. This year, we had in the Senate, we had a sponsor, Senator Eric Burleson out of Springfield, who is now leaving the Senate. He is more than likely going to be a congressman from the 7th District. And we also had Mike Heffner from the Kansas City area, who sponsored the House version of this bill that said no deed, restriction, covenant, or similar binding agreement running with the land shall limit or prohibit the installation of solar panels or solar collectors on the rooftop of any structure. There was a House version and there was a Senate version. In the Senate, Senate Bill 820 was the specific bill that addressed HOA covenants and restrictions with solar. Senate Bill 745 was kind of a more generalized utility related bill. If you are familiar with how the legislature works, language that a lawmaker likes that can be kind of tangentially associated with the subject of a bill, that language will get put onto a piece of legislation, and then so that ensures a greater chance of it passing. In this case, while the House bill didn't get very far, we had two bills that had this language in it. They both passed the Senate. They went to the House. They got passed by the House. And then eventually Governor Parsons signed them in June of this year. We are very excited about this because we see this as an expansion of property rights. We see it as an expansion of energy access. And we also I see it as a consumer protection bill. I see this as something that allows you to have a little bit of freedom with your HOA, which a lot of people find kind of unnecessarily restrictive in a lot of cases. So this is a good bill. This is a bill that Republicans liked, in addition to Democrats who like the renewable energy aspect of it. A lot of Republicans liked it because there was an element of kind of allowing people to do what they want with their property. And so that's an important thing to Republican conservative leaning lawmakers. Next slide, please. Thank you. So, so again, this kind of gets into what we can do now, in addition to getting rid of these bans. I mean, and I think that also is going to apply to this situation where an ACC just can't ban it, right? This says you need to put forward reasonable restrictions regarding the placement of solar panels. Don't have to. You can just let people do whatever you want, but if you're going to limit it, it has to be reasonable. Oh, and look, there's this is where we talk about those phone calls. So I've already kind of talked about that. Next slide, please. Okay, so this is okay. What is reasonable rules? This is what the language says in both of those statutes. A homeowners association may, not shall, may adopt reasonable rules subject to any applicable statutes or ordinances regarding the placement of solar panels or solar collectors to the extent that those rules do not prevent the installation of the device, impair the functioning of the device, restrict the use of the device, or adversely affect the cost or efficiency of the device being a solar panel or solar collector. These terms like reasonable and adversely affect are not defined. A lot of people in the solar industry have expressed frustration with that. This is absolutely something that comes into the legal aspect of this legislation. There's rarely ever a rule or a law out there that defines what reasonable is or what adverse is. And the reason we don't have definitions on that is because we want there to be some gray area. We want there to be some ability for people to kind of work this out on their own. We don't want to just have it so rigid that you've got to go to court every time there's a disagreement. That's not the point of the statute. I mean, if there's an enforcement issue, by all means, yes, then you should go to court. But it's a matter of just trying to make sure that we are allowing people to kind of work this out. So if you ask me, what does reasonable mean or adverse means? My question is, what do you think it means? Now, I do have some suggestions, however, and this is where I think this particular webinar can be most helpful. Corey, can you bring up that HOA language? We thought we had a link here, but we're gonna have to do this.
Yes. Give me 1 second.
Oh, is that you, God? Okay, thank you. Okay. I'm glad everyone's hearing me. Okay. Oh, look, there I am. Thankfully, I dressed
All
up
right,
for
can
this.
you see it?
I can see I can see like your whole screen. Is that the best we can do? Or can we do like a full screen on that or no?
I can try and
Doesn't matter. Doesn't matter. This is fine. If everyone on,
How about this?
that's better. That's good. That's good. And you don't have any embarrassing tabs open, so that's also good. Okay. I'm just kidding. I know Tori wouldn't have any embarrassing tabs. She's very professional. Okay, so 3 years ago, when we were going through this litigation in Taney County, Missouri, our office, in an attempt to resolve this, wrote up what we thought were what I thought would be pretty reasonable guidelines for not only making sure that a solar customer could put solar on their roof, but also that in a way that would also maintain the integrity of the HOA and to make sure they still had rules on this. I mean, these whereas clauses are pretty standard. I'm almost certain we picked this up from some other resolution that would be required for this. But so basically what's important is under this now therefore part. These are guidelines for solar energy devices. Don't go too fast on me there. Easy on that trigger finger. I want to make sure we're doing this now. I mean, so again, these are suggestions. I'm not saying this is what you have to do. I am not saying this is what the legislature was intending, or what Governor Mike Person was intending when he signed it. This is what we believe is something that if you're in an HOA or you were trying to resolve an issue with an HOA, this is something that you should start with. This is a beginning point. I think this is good. I mean, so we talk about, defining these devices. That's pretty we got that from another HOA in another state that had what we thought were pretty reasonable restrictions. Any so then we kind of get into obvious things like the fact that the device cannot encroach on another neighbor's property. It's got to be on the land or structure owned by the property owner. And then we envisioned an idea where you could send this to the ACC of an architecture control committee if that is in the if that's in the covenants. And this is what we propose. Now, again, I've kind of shown this to some folks in the solar energy industry, the distributed generation industry. I've not heard from anybody who thinks that there's anything unusual about this, but having a diagram drawn to scale by a licensed contractor installing the device, showing where the device will be installed, photographs of the roof area where the device will be mounted, plans showing visibility of the device from areas open to common or public access, material to be used and our manufacturer's description of the device, photographs and pictures of the device and color of the device, and where possible, provide photographs of similar existing devices as examples. Now, in my experience, and I'm sure that this might be the experience of some of the other people on this call, you will get a number of diagrams, kind of sketches, approximations about what these arrays will look like from above, from the side, from the front, from the back. That would be ultimately what we saw as a potential packet that you would deliver. And we kind of had like this initial part here where there would almost have to be an immediate, so where the ACC couldn't just sit on it, they'd have to approve, ask for more information, recommend changes, or deny the device, design or location as proposed, maybe provide an alternate location for the device, and they would have like 30 days to do that. If they didn't do it within 30 days, it would be granted. That's, again, another number that we got from another ordinance or a covenant somewhere else, not necessarily required by any law or anything like that. Keep going. Next page. Okay, so then you have, we had this idea that you could have automatic pre-approval by the ACC, where there would not need to be any other steps. Like we try to like kind of put this on here because if it's easy, or if it's if it's something that might have some obvious things that would not even be a concern to any other neighbors or to the governance of the HOA, we thought and this is really important too. Okay, I mean, like an obvious thing to put into your ordinance, into your covenants and restrictions is this has got to follow the net metering statutory guidelines. We have a whole other statutory scheme that defines how much power a net metering device can bring into your house, while being interconnected to the distribution line. That's easy to point to that and say it's got to conform with that. It's got to conform with current building codes. Now this is tricky, and I'm going to kind of talk about this a little bit later in the remaining time we have on this webinar. Often, like let's say, for example, you're an HOA, a homeowner association in a larger town or city that has existing zoning. Almost certainly, to get that HOA built, you had to get that approved by that zoning office or that city. Same case would be in a county if it has a zoning office. Not a lot of counties do when you compare it to the 114 counties we have in the state, but some of the larger ones do. They're going to have to get that subdivision approved. That also means they're going to have to get the covenants and restrictions approved as well. So there is going to be a process to where there wouldn't necessarily be a violation of any building code because that's already been vetted when this was built. Again, that's an easy thing to put in there. If it's a roof mounted device, having that installed parallel to the roof line, so there's nothing unusual about how it looks. It just runs flush or closely flushes with the roof. That's something that might not really be a big deal. Entering wiring or other components that are concealed as much as possible. I mean, just as long as there's nothing running along the walls or the roof that's going to be facing the street. And so say ground mounted devices. Now, this is something that's important to point out too. If you look at the language of the statute, it's silent on ground mounted devices. In theory, a HOA could still ban those. That's not something that the statute prohibits them from doing. However, it is my belief that there should be no reason to bar or prohibit a ground mount as long as it's in your yard, it's in your backyard, and you can't really see it over the fence line. And so saying that seems perfectly reasonable to me. And then also going back to E, I think I just skipped over that because this is really important. Keep in mind, this is for pre-approval only. The roof-mounted devices are located on the rear-facing roof or side of the house. Obviously, you're going to have questions about what that means. I'm going to get to what that means here in a minute. Now, that's pre-approval. If you wanted to look at a way to, where there might have to be more deliberation. Let's scroll down a little more, Tori. Okay, that's good. That's good. Thank you. So if it doesn't follow those pre-approval rules, looking at how the device is higher or beyond the perimeter boundary of the roof, is something that could be explained by the solar installer as to why that's important. That's something that we think that would resolve that as long as there's a reasonable reason for it. If piping and electrical connections are located directly under or within the perimeter of the panels, when possible, in place as inconspicuously as possible when viewed from all angles. That's, again, if you cannot show that they can be completely concealed, that's something that, as long as you had reasonable language like that in there, that's something that should be able to resolve that. Solar shingles, this is going to become, I think, more and more common. You're going to start seeing more and more people do that once you see that technology advance and that technology become less expensive. You're going to see that. So if they look like composite shingle, there should be no issue there. And number 5 is probably the most. Let me make sure. Let me see 5 really quick. Oh no. Okay, that's okay. These two are important. 5 and 6 are important. When we're talking about the reasonableness of. Okay, I'm going to skip to 6 because I think this matters. All right, if it's facing the street, because it seems to me like the biggest problem that any HOA has is with a street-facing roof having a solar panel on it. Why would that matter? Well, it would matter if you had a southern-facing roof or western-facing roof that faces the street. Anybody on this call or anybody involved with solar will tell you that a solar ready roof, a roof that is going to be most conducive to seeing value and benefit to your customers, is going to be one that faces the south and the west, generally when you have the most power of the sun working in your benefit. If your installer can explain that in a letter, that should be okay. But let's say that they still want an alternate location. Well, one of the things that this can't do is restrict, the efficiency of this system. That's in the statute. That's gonna go into effect on August 28th. So if you're talking about an alternate location, what should your measurement be for that? Well, this is something else we got from another HOA covenant, which we thought made sense. You look at INREL or you look at some sort of available modeling tool, and it shows that if you move it and you don't reduce that annual energy production by more than 10%, that is a possibility of being a reasonable rule that doesn't really have a significant amount of harm to the homeowner. It's not perfect. It's not ideal. Obviously, you want to get as much available efficiency as you can, or as much production as you can. But that's just a way of maybe making that more tangible. So that there, I think, is important when we're talking about the idea of alternate locations. Okay, let's go down to B. Yeah, if this is a ground mount, again, it may not extend above the top of the fence unless authorized. It might matter if the fence is not solid. It might need to have a visual screening. I think as long as the solar installer could explain whether or not that screening would have an impact on the effectiveness of that system, that's something that you know, could be considered as well. Keep going down. Yeah, and also another one. These are easy to make sure that the solar array conforms with manufacturer's instructions, warranties. You know, making sure that a licensed installer puts that in, and make sure they have the proper permits. These devices should not be able to threaten public health or safety, violate any laws, or interfere with the use and enjoyment of land, causing unreasonable discomfort or annoyance any adjoining property owner. That could be, I mean, like, you know, I know I've heard people say they complain about whether there's a glare that comes from solar. I mean, I've not really ever seen a residential scale net metered array that has any kind of glare. It might be one that wouldn't be any different than another piece of metal on your rooftop, but I don't know if that would be a substantial interference with the use and enjoyment of your neighbor's property. It could, I mean, if you have got a light source that is going into your neighbor's property, like let's say you've got a massive light that like beams into their living room, beams into their bedroom at night. I mean, that's technically a civil trespass issue. You are, you know, kind of having a forced entry onto someone else's property. So that's what you would call it. Seems odd to call like a light transfer or anything like that trespass, but that's what we would do in civil law. Again, another thing that's easy is making sure that this has got to be maintained in good repair. If it's not being used, if it can't operate, it should be removed. Yeah, so, and then we have this last one, a variance to certain sections of these guidelines may be granted if compliance with these guidelines would significantly increase the purchase price of the device or significantly decrease performance or efficiency. If a homeowner seeks a variance, they must provide a minimum of 2 bids depicting the cost of the installation of the device, 1 bid in compliance with these guidelines, and a second bid depicting the desired alternate location, unless the variance represents the only feasible installation location. The Architecture Control Committee may require bids or estimates from a second contractor in order to make an informed decision. For purposes of the exception, significant means amount exceeding 10% of the cost of the system or decreasing efficiency or performance exceeding an amount of 10% as originally specified and proposed. Again, there's nothing magical about those numbers, about the 10%. That's just something that we've seen in other covenants and other restrictions, and we think seems like it would be agreeable to most reasonable parties. Okay, do we have anything more on this? Is that it? Oh, we're done. Yeah, and by the way, if you're asking, if you have signed up for this, we will. Hold on a second here. Sorry, everybody. So, okay. Okay, next slide. Okay. Again, this will go into effect on August 28th. That's when all laws that do not have an emergency clause go in on August 28th. Why is that? Again, it's my favorite bit of Missouri trivia. It is because that is when the day that the Missouri Constitution was ratified. That's why laws go into effect that day. However, the difference with this law is you can't enforce this until January 1st, 2023. The reason that is, and that was not in the original language, but that was added during the Senate process, was so HOAs would have some amount of time to comply with this, to get those things in place before we started that you would already be able to make sure that we had time to do that, to make sure those rules and covenants got put in place. So that gives them a little bit of breathing room on that. Next slide, please. Okay, again, and we kind of went over this, keeping in mind when determining rules regulating solar devices, the location is the important thing to determine the effectiveness of array. South and west facing portions of the roof are the best places for panels to soak in sunlight at peak times. Surfaces that do not face the street, good. South or west facing portion faces the street, not as good, but new rules could stipulate that the arrays can be allowed on the front of the house if documentation is provided. It might be more work for the installer, but I do believe that does kind of watch out for not only the rights of the solar customer, but also for the integrity of the HOA covenants. Everything should be done to make sure wires and other incidental equipment is concealed, covered, since that is something that also can be considered an eyesore. And solar shingles should mimic roof requirements and composite shingles as closely as possible. So if there is ACC requirements about roofs or shingles, that should probably be the same thing that we keep in mind for solar shingles as well. Next slide, please. Yeah, again, only applies to rooftop solar. Ground mount still does not need to be approved at all, but I do believe that there's no reason to ban ground mount as long as it's something that other landowners wouldn't see. Yeah, so I think, and there also might be a question of, we were talking a little bit about color. I mean, does your solar array have to be black? I talk to a lot of solar installers who say yes. So, I think that, anything involving a change of color might be too much, might not be considered reasonable. Again, reasonableness hopefully gives people in the solar industry and HOA board of directors some sort of ability to come to a common agreement on that without having the courts involved, which would be good. Next slide, please. Yeah, so and whether or not this statute supersedes any other like existing rule, any case law about how we regulate, and we talk about how these kind of covenants and ordinances kind of coexist with other government regulations. I mean, we had a case where a landowner, homeowner, a supporter of Renew Missouri, sued, kind of went through a circuitous route of dealing with the Public Service Commission, since they were like the regulatory body that deals with net metering. But, one of the issues there was the city where this HOA was located denied their application based on an ordinance addressing solar energy systems. That ordinance required the use of non-glare material on the PV panels and the frames support that be of minimal reflective material. These provisions were not addressed by the statutes. The court needed to determine whether these provisions were allowed under that law. Next slide, please. The court examined the precedents to determine when local regulations may exceed state statutes. Local regulations may exceed state requirements so long as they do not prohibit what state law permits. A city may only enact ordinances in conformity with state law on the same subject. And in that case, the court recognized that the state may have no concern and thus have no restrictions regarding the use of reflective material that shine bright sunlight into a neighbor's window, or the way the solar panel may appear from the street or a neighboring property, so as to potentially devalue the neighboring property. And the court did determine these types of restrictions are within the police powers of the city, because even though there is a net metering statute, the net metering statute didn't address those specific things. Again, that was an issue where it was an ordinance issue with the city, but that still was born out of a dispute with the HOA, because the HOA went and got that city to change their ordinances. Next slide, please. Oh, we're done. I've got like 5 minutes left, which I can talk, but does anybody have any questions? You can write them down. I don't know, Tori, do we have the ability to see people raising their hands or anything like that?
Yeah, people should be able to take themselves off mute, or actually just put the questions in the chat.
Put the questions in the chat while we're While we're talking about that, one thing I'm going to note, and this might be of interest to people on this call, is last week, the Missouri Supreme Court did rule that the statute that exempts solar equipment from the state property tax was unconstitutional. Essentially, the Missouri Supreme Court said, somewhat predictably, in my opinion, that that exemptions to property tax must be done within the Constitution of the state, not within state statute. So since that exemption was only done through statute and not by the Constitution, that the legislature did not have that ability to do it. The question that we're trying to process now and deal with now is whether or not, in light of this, because the court didn't give any guidance on what kind of property tax should be assessed to solar equipment. It just said that the exemption is no good. So it's left kind of a vacuum here. Can that get filled by the county? In the meantime, I don't know right now. Also on August 28th, there is a solar property tax task force. That's not the name of it, but that's what I'm calling it. There were some efforts in the legislature to add a property tax to solar in the past couple of years. All of those were relatively unreasonable. We got very close to having a reasonable kind of resolution between the Missouri Association of Counties as well as a lot of solar providers. I'm very hopeful that we can still come to a resolution for that. And I do hope that we are able to get that question resolved by next session before the county collectors and the county assessors do anything that would be considered, let's say draconian to the solar industry in the state. I'm only adding that because that is that was a new angle since we wrote this up. Are there really no questions? I will say, because I got to drag us to 221, folks. I will say we're going to be doing this seminar a couple more times. I know the next one we're doing is on August 30th. That's going to be led by Andrew Linares out of our St. Louis office, another really good lawyer who will be able to talk about this as well. So if you like this or you want to see this again, I don't know why you want to see it again. Quite frankly, you probably want to see these model ordinances we have. And we're happy to share that. We can certainly get that to you when we send this out. We also did record this, and we're hoping that we'll be able to share that with the public as well. So yeah, and I can also tell you Renew Missouri is working on a CLE that's going to get into the Inflation Reduction Act that we anticipate President Biden will sign today, that has a lot of clean energy provisions in it. Oh, thank you, Ethan. Yes, questions and compliments are always welcome. So I hope this helped. I hope that if you want to ask any other questions, james@renewmo.org is my email address. So I will try to make sure I get that addressed to you. So I think with that, my clock is showing it's about ready to be 2:21. Oh, it is 2:21. Thank you for listening. Thank you for your time. Thank you for supporting Renew Missouri, and we'll talk to you soon. Bye.